Wait, please, Your Lordship. Lordship, I would like to mention for listing of two cases, MSc appeals, Lordship, Bakija proceeding has started, so we need it on Monday, Lordship.
What? On Tuesday?
Tuesday
Maybe it's a
is
hearing date, but we can accommodate.
Okay.
Tuesday, fine.
Already Bakija has, they have, that proceeding has started, Lordship, because it will come for admission and we will deposit the amount. That is the thing.
Okay.
The basin of
Tuesday, Koji.
highly obliged.
May I please, Your Lordship? On the consent of the others, I beg to mention item number 15 of today's list.
Hmm.
They have filed their affidavit. Kindly 2 weeks' time may be granted to file or rejoin their affidavit.
Learned Counsel Miss
M.
Ambra,
Bora.
with the consent of the other side, has paid for adjournment to file affidavit in reply.
Reason their
List this matter after 2 weeks. You said 2 weeks, no?
2 weeks. Obliged.
May I please, Your Lord?
Hmm.
My Lord, sir, to MSc appeal, my Lord, may I play for listing on this next week, my Lord?
Okay, next week, appeal.
Appeal.
Hearing, the stage of hearing?
My Lord, orders matter, my Lord.
At the stage of orders, okay. Next.
Opening Your Lordship, I beg to mention it, for praying for the listing of the case, the transfer petition matrimonial case, and there is a stay is out there, and last listing in the month of September. So
When
it,
do you want?
uh,
5th of February, fine. Yes, on 5th of February.
May I please, Lordship? Lordship, I beg to mention listing RSA for orders column, Lordship, next week.
Okay.
May I please, Lordship?
অলপ চাই দিব ক'বা দেই নেক্সট উইক মানে অলপ মানে কম্পেক্ট কৰি কৰি আজি বহুত কেছ দিছে
May I please, Lordship?
ইমান বেছিকে দিবলৈ মানা কৰিবা এডজাষ্ট কৰি পেলাই ব্ৰড ফৰৱাৰ্ড বোৰ ব্ৰড বাই অৰ্ডাৰ বোৰ
Lordship, I am praying for MFA. It's relating to matters.
when do you want
Lordship, on
orders column
it is a hearing columns. Lord,
Hearing.
maybe taken is a third week of and 19
hearing এটা
19 high level.
May I please, Your Lordship?
Hmm.
Lordship, I beg to mention item number 13, Your Lordship. I have
Hmm.
taken consent from the other side, Your Lordship.
learned counsel Mr.
S.A. Hussain, Your Lordship.
S.A. Hussain with the consent of the other side has paid for adjournment.
After 3 weeks, Your Lordship.
Leave the matter after 3 weeks.
may I
My
please,
Lord.
Your Lordship,
Hmm.
I beg to mention item number 1, my Lord, may be taken next Friday, my Lord.
Learned counsel Mr. W. Roman
Yes, ma'am.
has paid for adjournment. List the matter on next Friday. Read to videos.
Well,
May it please, Your Lordship? I beg for listing of one CRP, Lordship.
Hmm.
Can it be on next week?
Which column?
Motion.
Can be on next week.
May I please, Your Lordship, I'm going to mention one MFA for hearing column, Lordship,
Hmm.
on 26th of February.
Finding hearing. Yes.
Lordship.
May it please, Your
Hmm.
Lordship? Your Lordship, item 32, kindly pass over the item for the day.
Your name?
A. Tapadar.
Learned counsel Miss A. Tapadar. On behalf of Learned counsel Miss Archori has made a request for Passover for the day.
Okay.
May I please, Your Lordship? Your Lordship, I beg to mention two IAs for listing. One is for substitution and the other one is for injunction, Lordship. Can it be listed on Monday, Lordship?
Not on Monday.
Then on Wednesday.
Wednesday, yes.
Obliged.
Fine.
That's to mention, Lordship, one matter has been hearing, Lordship. Already hearing was done, but thereafter, after taking the adjournment, matter was not listed. That is the hearing on 17/9/2024. Thereafter, matter was not listed, Lordship, MSc appeal. So matter may be urgent. So Lordship, I have been filed.
Just a moment. Hearing matter. কেতিয়া দিব পাৰি? 17 on 17 February.
17th, highly obliged, Lordship. And another matter, Lordship, we have filed the IA, but that was for releasing the amount, Lordship. I am from the claimant of the respondent, Lordship. So matter may be listed for the IA, Lordship.
For I.
Oh, yes, Lordship, on next week.
Next week.
On
Date
the
টা দি দিয়কচোন।
5th
February.
Yes, Lordship.
May I please, Your Lordship?
Lordship, earlier was rejected, Lordship, and at the time of investigation stage, Lordship. Now, Lordship, charge sheet already been submitted, Lordship, and trial proceeding already been started. And POCSO 12 is there, Lordship. But what
Can
Lordship,
issue notice?
notice, Lord.
Learned Counsel Mr. F. Hock is present for the petitioner. Learned Additional PP Miss S. H. Borano.
Lordship.
S. H. Bora is present for the respondent state. Petitioner to take steps to issue notice to the respondent number 2, returnable within 4 weeks.
Lordship, and there is possibility.
Returnable on when
amicably
do you want?
settlement, Lordship.
Huh? When do you want?
Lordship, and the 17th of February, Lordship.
17 February পাই নাকি?
Lordship.
19 February, meanwhile, call for the scanned copies of the child court records.
Lordship. Published, Lordship. Published. Published.
One day, থাকক দিয়া অকমান দেৰি ওলাবহি।
The application for transfer of the divorce matter filed by the husband at Hailakandi matter. I am only the daughter of my family. I have got no mother. My father is seriously ill. For which I am in Silchar, my lord. And since last 2 years, I have been neglected for.
Only half an hour journey from.
My question is that DB case is pending at Silchar. He is regularly coming, and 120 case also have filed. So he is coming. Well, we'll adjust all the dates similar time at the time. Kindly help. Save my life. I am not getting any maintenance. I have got no means also.
Will issue notice.
Well, kindly further proceeding unless your lordship stay. I have to go with my child on late. That's why.
How old is your child?
9 years.
9 months only.
Learned Counsel Mr. S.C. Biswas is present for the petitioner X, who has preferred this transfer petition as the petitioner is nursing a 9-month-old child and she has to travel up to Silchar.
Pardon?
Silchar or Hailakandi. Where has
Silchar, we want Silchar. It is in Hailakandi one.
And she has to travel up to Hailakandi, full stop.
And husband is attending at Silchar.
It is submitted that the petitioner is a resident of Silchar and a case under the protection of the domestic violence or what is the act? Protection of women from domestic violence, 2005.
Yes, it's pending. He is attending regularly.
At Silchar.
Silchar.
Full stop. Considering the submission that the petitioner is the mother of a 9 months old child, the proceedings of TSD case number 69 of 2025 is stayed till the next date of listing. Issue notice to the respondent. Returnable on data diopson. Stay code is no data diop. February.
I beg apology. It is not 9 months, 9 years matter.
No, then I'll not grant stay. No. We'll issue notice.
Well, then I have got no means. Kindly help.
We'll issue notice.
Save my life, my lord. Who will look my father? There is none at my home. That is the problem, my lord. Being a woman, my lord, I have got equal duty to my father also, kindly.
I understand, but not to state or the issue notice. We'll issue notice. I thought it's the child is 9 months old.
Then, my lord,
we'll issue notice.
That's true, your lordship will issue notice. Naturally, but I have to go attend the court, man. That is the problem. Kindly save my only for few days.
The prayer for interim stay will be considered on the returnable date. The petitioner may take adjournment from the trial court on the next date fixed. It will stay paragraph to paragraph. Date like it.
My lord, the transfer petition, my lord, whereby petitioner seeking a title suit to be transferred from the North Salmara Obhayapuri to Gwalpara, my lord. That is page 41, my lord. matrimonial suit, my lord, has been filed by the wife against the husband. But my lord, the ground is the personal security, my lord. Once, my lord, she attacked the petitioner in the court premise itself. There are several litigations, my lord, submitted. In one litigation, my lord, we have filed transfer petition, and this honorable court has granted, my lord, stay. In that case, my lord, can we have a look at page 34, my lord? That is in respect of PRC case, my lord. We are the petitioner was appearing. Suddenly, my lord, he was attacked by the respondent, my lord, in the court premise itself. This is the petition, and the order of the trial court also reflects the same, my lord. It page 33. You kindly may be paid. Now, my lord, please turn to page 33 of the learned court's order, my lord. Page 33. Lordship has seen. Now, my lord, in this on this ground, my lord, this honorable court has granted stay in the PRC case. That is, my lord, page 37, my lord, can be seen. And relevant portion may be seen at page 38, my lord. Considering the contentions made in the present petition and also the allegations pertaining to physical assault on the petitioner on his appearance in the matter before the court of learned SDJM, not Salmara. So and so, further proceeding in PRC case number so and so shall remain in abeyance till the next day. Thereafter, my lord, it was subsequently, my lord, in the order dated 29/11, my lord, stay has been, my lord, extended. My lord. Now, my lord, on the same ground, my lord, I am praying this case also to be transferred. My lord, the respondent also in a better position that she is serving in the Gwalpara district, my lord, in Chunari, and it would be nearer than Obhayapuri court, my lord, to her.
What is the place?
My lord, it
Chunari.
is Chunari, my lord, Lakshmipur, under Lakshmipur PS
Chunari.
within Gwalpara district.
All right. What is your name?
M. Ali, my lord.
Learned Counsel Mr. M. Ali is present for the petitioner X, who has filed his application for transfer of TS case number 104/2024 pending in the court of the Civil Judge Junior Division North Salmara Abhayapuri Bangagaon. The case was brought up by the respondent number 2, wife of the petitioner.
My lord.
It is submitted that the petitioner is under serious threats. Earlier, the petitioner was attacked and a complaint was lodged against this attack before the learned SDJ, within bracket, North Salmara at Abhayapuri. The petitioner was present in connection with PRC case number 337 of 2022, where he has been arraigned as an accused.
Yes, ma'am.
He has been arraigned as an accused, After he was attacked by the informant, who is the
Informant is wife, my lord. She, along with her man, my lord, attacked in the court premise.
informant, along with her? Along with some other persons. The petitioner had approached this court for transfer of another case registered as, or that same case, for transfer of PRC case number.
Yes, ma'am. Yes,
Same case.
So it was
337
337/22,
of 2022.
and the transfer petition, my lord, 30
Right
of
order
the
dated 12/7/2024 in TRP criminal 32/2025, comma, the proceedings of PRC case number 337/2022 were stayed till the next returnable date. To stop, it appears that there are prima facie grounds to stay the proceedings of the present case, comma, at least till the next date of listing, thereby. To stop, thereby, the proceedings of TS case number 104/2024 is stayed till the next date of listing. Learned,
My lord,
It's probably made as a party lordship.
that may be omitted, my
Yeah.
lord. It is a civil case.
issue notice to the respondent number 2, returnable on date due.
Till then, it is kept in abeyance. Highly obliged.
May I please, your lordship. First, is for transfer of a divorce petition, my lord, pending in the court of my additional district and session just Nagaon. So, my lord, Guwahati, my lord, family court Guwahati. But I am for the wife, my lord. So, my husband has filed a petition, my lord, for divorce before the additional session.
The issue
Guwahati.
notice.
My lord, there is, my lord, I have a 4-year-old child, my lord. And it's difficult for me to, and moreover, my lord, there is threatening, always threatening from the brother of the, my lord, my husband. If I go there, my lord, they will either keep me, my lord, keep my child, my lord. So because of that, my lord, I could not appear before the court, my lord. And though
We'll issue notice.
my lord, the proceeding may be stayed for the
Next date we will, after returnable date. Learned counsel, Mr. R.K. Dutta.
user circuit.
Mr. Uja Sirka is present on behalf of the petitioner X, who has filed this case with prayer to transfer the matrimonial D case number. TS, it will be TS, no?
Matrimonial D case number 63/24.
Matrimonial D, divorce case.
Divorce case. Divorce case.
Hmm?
Divorce case.
Decree of divorce.
Degree of divorce.
Matrimonial D case number 63/2024 under section 13 within bracket 1 within bracket B of the Hindu Marriage Act 1955. Full stop. It is submitted that the petitioner has a 4-year-old child and she is always under threat as a brother-in-law has threatened to. Where, in which paragraph?
My lord, it is in paragraph number 6, my lord. States that the brother of the opposite party is
Brother-in-law has exercised threats to the petitioner. Full stop. To consider the prayer for interim stay, comma, the prayer for interim stay will be considered on the next returnable date.
Interim may be considered, my lord, because my lord, I have to go there, my lord, this is the.
Meanwhile, you can take.
Moreover, my lord, I have to go alone with the child. My
On returnable day, we are,
I have
on returnable date.
no other male person is also there. My father also expired, my lord. I have to go alone with my child.
You
And
can
therefore,
take
7, 8
adjournment for
days.
1 day.
It takes, my lord, 7 to 8 hours, my lord.
You don't have to come on, you take adjournment only for 1 day. Advocate will take adjournment, you don't have to come. This is not a family court. Is it a family court?
It's the additional district and session judge number 3, my lord.
So it's not a family court. You can, advocate can appear and take adjournment. The prayer for interim stay may be considered on the returnable day. Meanwhile, issue notice to the respondent, returnable on date adjudication. The petitioner may take adjournment in connection with the aforementioned case on the next date fixed. Only 1 date.
May it please your lordship. Lordship, I have come against the order by which I was debarred from filing my WS. What had on the 89th day,
Mm.
what had happened, the lawyer which whom engaged
Mm.
and handed over papers met with an accident. So he had to be rushed to Delhi. In these circumstances, I filed this petition for seeking adjournment, but the court refused. But at the same time, in the Miss case, on the same ground that my adjournment petition was allowed. So these are two contradictory sets, and it is not an absolute bar that 90 days is nothing absolute. So in circumstances, may justify extension. So, but the court, this is what I have come against. The impugn order is at page 31, Annexure 4. Lordship, it appears that the statute, Mr. on the ground that the conducting counsel, J. Ahmed of Dipan, is under medical treatment in Delhi due to motor accident on 5/9. This petition is supported by certain photographs and copies of medical documents issued in the name of Jainud Ahmed. Heard and produced the CR, it appears that the statutory period for filing WS by the defendants had already been over today, as the summons were served upon the defendants were served on 4/8/2025, which is reflected in the video guide order dated to 29/2025. As such, in view of the same, I am not inclined to allow further time to the defendants for filing WS. So this is what she has done. And in the Miss case, Lordship will find at page 35, 32, he says, learned counsel for the opposite party number 2 has right petition bearing number this prayed for allowing time to file written objection on the ground that the conducting counsel this and this of the opposite parties under medical treatment Delhi due to motor accident. Heard, perused, prayer is allowed. Just because 90 days would, whatever the 89th day, would expire without considering the special circumstances, he has simply barred my filing of the.
Have you annexed the earlier orders?
Which orders, Lordship?
Earlier orders of this court? Title suit number 37 of 20.
Only one date was there before this one.
Only one day.
Oh, yes. 28th of September. And Lordship, this is not an absolute. And if the counsel who has the papers, everything is under treatment. This.
You have any authority with you?
Yes, Lordship.
Just mark the paragraph, relevant paragraph. One authority will do this. Where's your ground on the petition?
On which petition, Lordship? Page
Paragraph?
9. Page
This is
9.
Paragraph
27.
Page 9, paragraph.
Page 9 are the grounds, Lordship.
Main ground.
Main ground is despite the fact that the main ground is she, and then again being to prevent miscarriage of justice. 4, 3, 4, and Lordship 5 is also there. 3, 4, 5, and 6. 6 is about the accident.
Okay, I'll send it back.
Yes.
You submit your WS.
Yes.
Third learner senior counsel Ms. M. Hazarika for the petitioner.
Defendant. Defendant number 1. In the suit.
Who has been added as defendant number 1 in TS number 37/2025 Full stop. The petitioner has been debarred from submitting written statement by the order dated 1/11/2025 in TS number 37 of 2025. Full stop. It is submitted that the petitioner will be highly prejudiced if he is not allowed to continue the proceeding by submitting written statement. Full stop. It is further submitted that in a similar circumstance, in Mijay case number 53/2025, on the same date, the petitioner was, however, allowed to submit his written objection in connection with the aforementioned miss case. Full stop. It is submitted that that 90 days, the statutory period to file written statement within 90 days is directive and not mandatory.
Mandatory.
Full stop. It is further submitted that under the circumstances, under the facts and circumstances, the learned counsel for the petitioner was undergoing treatment after a major accident, the order debarring the petitioner from submitting his written statement appears to be harsh. Full stop. The learned counsel for the petitioner has relied on a decision of the Supreme Court in Kailash versus Nangpo and others, wherein it has reported in
Reported in SCC
2005.
2004 SCC
2005 within bracket day 4 SCC 480,
480
wherein it has been held at para 27.
27 32 20 not 20. Lordship 27 28 okay. From 27 to 42 Lordship can say.
No. Not from 27 to 42.
Huh?
Not from 27 to 42. The
From
relevant
32 32.
32.
Yes. Why did you not get 27 sometimes? 27 is a wrong one.
Twenty-seven লিখি দিবা
27 to দিলে হ'ব নেকি?
32 দিয়ে।
And 32.
32 is good enough.
32 is good enough.
Mm.
Submissions. 32 is,
Another paragraph you want to add?
32 is good enough.
A pragmatic view is taken by this court. Full stop. It appears that the petitioner may be accorded an opportunity to file this written statement and contest the proceeding. A cost?
Not his fault, actually.
Not his
Just
fault.
one.
Without issuing notice to the respondent, this court deems appropriate to accord an opportunity to petitioner to appear before the learned trial court and file his written statement. Thereby, the imperial order dated 1/11/2025 is set aside, and the petitioner is directed to appear before the tribunal within 1 month from the date of this order and file his written statement.
Obliged.
And submit his written statement. In terms of the above observation, this petition stands disposed of.
Obliged.
Pragmatic views taken for the interest of justice to a line of a act to the leader.
May it please your lordship.
Lordship, this matter may be placed before the mediation.
Okay. Miss Argus, Miss
P.
P. Botaku is present for the
Appellant.
appellant and Mr.
DK Kolita
DK
for the
Kolita.
respondent number 1.
Is present for respondent number 1. Full stop, there appears to be an element of settlement, thereby this matter is referred to the mediation center. Full stop, matter to be placed before the mediation center immediately, and thereafter the mediator may submit report after two months or 1 month.
2 months.
After submit report after 2 months, i.e. after 6 weeks.
6 weeks.
After 6 weeks relating to the outcome of the mediation.
I have not received a copy of memo of appeal, Lordship.
Copies to be furnished to the respondent. Extra copies to be furnished to the respondent.
Awesome.
Wait, Lordship, this can be sent, Lordship, for mediation.
What about the other side?
Other side, I have the phone number, their names are also appearing.
Hmm.
But we are the appellant, I do not know. Lordship wants to wait for them or fix another day.
We'll fix a date.
Okay.
Learned Counsel Ms. Hardy Muzumdar is present for the insurance company. The names of the counsel representing the respondents are reflected in the cause list, but the respondents are not represented today. List this matter after 2 weeks.
Otherwise, service is complete, Lordship, so it can be heard also both ways. But then if Lordship wants.
1 date only.
Okay. Hello,
In the same, under the same column.
hello.
Lordship, and for the appellant, can we refer the matter to the mediation?
Can be referred.
Yes, my lord, we have not received the copy of the appeal.
Alright, you'll get it. Learned Counsel Miss
D Dash, on
D.
behalf
Das
of NN Jha.
is present on behalf of Learned Counsel, Mr. N.N. Jha, representing the petitioner. Learned Counsel, full stop area. Learned Counsel Miss
M. Chetia.
M.
Corresponding
Chetia?
to
No, your name is.
M. Chetia.
No, your name is in the cause list.
Oh,
Yes, Learned Counsel Miss M. Chetia is present for the respondent number 2.
responding to.
Full stop. It is submitted at the bar that there is an element of settlement, thereby this case is referred to the mediation center, and the mediator is directed to submit a report on the outcome of mediation after 6 weeks.
2 months.
2 months should be given, I know. After 6 weeks, meanwhile, extra copies to be furnished to the respondents. You can take, they can extend for time, they can ask for some more time. I think this period is over, that mediation drive.
No, this is second, Lordship.
Second.
They are
again?
calling it a mediation drive 2.0.
Okay.
That was 1.0.
When was it extended?
From January, Lordship.
From January?
Apex Code did that.
Okay.
May it please your lordship, kindly pass over the matter for time being noted.
Pass over for, no, you submit. You can submit if there is an element of settlement.
There
Yes.
won't be any element of settlement, Lordship, because there is a pay and recovery order.
Okay.
So they are the owner. And we have already paid. So how can it be? Of course, if they are ready to pay, then okay. But they have filed the appeal.
Are you ready to pay?
Kindly pass over the matter for time being lordship.
No.
Otherwise, delay, it is still in the delay condonation stage, and we have filed our objection.
We'll defer it for another date. Okay. Where is the senior?
He's so.
Where is he?
Please legs on another court lordship.
Okay, we'll wait for 5 minutes. All of you are full day.
So, like.
Lordship, I'm appealing for the respondent number 1.
We'll send it for mediation.
My lord, on the last occasion, my lord, it was not amended settled lordship. If my lord, respondent, my lord, desired, my lord, another attempt may be taken, otherwise, my lord may be
So
listed.
there was already mediation.
Yes. Otherwise, it may be listed.
It was not settled.
My lord, not settled, that time it was told that the
Locadalet
next time they will
was
try.
listed before Locadalet? No.
Ma'am, it may be,
Lokadalat, it was not. Yes.
There is an element of settlement.
no, ma'am, Lordship, it may be placed before Lokadalat instead of mediation.
No. Lokadalet, we do not know any future date of Lokadalet. As yet. Maybe there may be Lokadalets, but not, we do not know. No scheduled dates.
Otherwise, may be listed, directed to be listed for hearing, fixing a date, lordship, my lord. If my lord, insurer, my lord, desire, my lord, I have no objection to.
You're for the
send the
insurance
matter to
company.
Yes,
mediation,
Lordship.
lordship.
Is there any element of settlement?
Lordship, I have no idea, Lordship.
Another attempt may be, my lord, taken.
You'll obtain instructions then,
Lordship.
okay?
Lordship.
Instructions, letter obtain instructions. Learned counsel Mr. M.H. Ahmed is present for the appellant and learned counsel Miss
P. Goswami.
P. Goswami is present on behalf of
K.K. Bhatto.
learned counsel Mr. A.K. Bhutto representing the respondent number 1. Host of the learned counsel for the respondent has submitted that she may obtain instructions if there is any element of settlement in this case. List this matter after 1 week.
That may be fixed, lordship.
List
Otherwise-
this matter on 10th.
Lordship. Lordship.
Mm.
How like?
Nice.
Any element of settlement?
I've got no objection. Let us try.
But again, this is also by the owner. Owner, no, generally.
Yes, let us say if it is
Let's
decided.
see if the owner is willing
Only
to pay.
the point raised there, the contributed negligence on our part, but it is not established. Contributed negligence is something different matter. Our own High Court
What is
judgment
the
is there
vehicle?
by my Lord Justice Devashish Barua.
Okay.
What is contributed negligence? They raise the contributed negligence. Court below has turned down our claim on the point of contributed negligence.
What is the vehicle?
It's a bike.
Bike. And the owner, what is it?
The other person, my Lord. But he is having registered RC book and the
Is the owner of
license.
the bike?
Yes.
What was the amount of compensation awarded?
Nothing rejected.
Okay.
Dismissed.
Compensation was rejected.
On the point
So
of
on dismissal case, lordship, it will be needing adjudication, not mediation. It is not a fit case, but still if they want, I do not have any objection. It can go.
It is not I want, it is the High Court has decided the matter.
No, High Court fit cases
No,
are
then
not.
it will, if you want to raise merits, raise issues on merits, then we will not send it for mediation then.
I leave it to you, because it has come in the list, but we do not know. We also not discussed by the legal services committee. But on their own derivation, they have picked up these cases where possibility is there.
You are the owner.
I am the claimant.
You are the claimant. Okay. Insurance will not pay for the owner.
Let us see if they don't pay. It will reward here again.
Owner, there doesn't appear to be any, unless and until you give up, claimant, unless and until you give up, you say that I do not want any compensation, then this matter may be settled, but there.
Then what for have come in the High Court?
So then.
Come for compensation, my lord.
So that's why I'm saying that.
Well, let us try, what is the wrong? Because the idea behind the Supreme Court is that maximum mediation attempt may be made. Nowadays, it has become a call of
But
this.
there has to be an element of settlement. What's
Yes,
the point of sending
exactly
it,
correct. Lordship.
and
Fit case and
getting a failure report,
Yes, correct.
sending it and then thereafter getting a
But,
failure.
Correct.
in many cases, even in mediation send also, it has been failed. I have latest experience, but we have filed for enhancement. one insurance company has enhanced to 1 lakh. Other insurance company, now they have deposited 1 lakh in the High Court history. Other insurance company has said, no, let it be decided with the High Court. My part of the compensation.
When the claim
What
petition
I
is
can figure out is this, there is no element of.
no element, exactly.
No, I leave it to you. If your lordship find that there is no material for mediation, then it will be, High Court will decide the matter. in the-
Yes, we'll fix it for hearing. Both the parties are present, we'll fix it for hearing.
Yes, yes.
Owner is not present.
No, I think other party has.
The claim application is dismissed on contest. The claim application filed by the claimant was dismissed on contest. So if that be so, lordship, how mediator can settle? How
No contest.
why
fine.
the insurance company a dismissal case, lordship? How a official can say that no, we
Then
are ready to
eh,
pay the
What is the category of sending the mediation cases, madam?
fit cases? Yes, there are.
What are the
And
categories?
notice has been served to the owners.
Yes, we have sent. Honorable Court has issued the notice long ago. We have taken steps, but they have not appeared. I do not.
Let's see the office, no? No person in the address found.
Address found?
Owner. 24/11/2025, R1 has been duly represented by learned counsel by filing wakalat number. Answer notice of R2 has been received back with the postal remarks, no person in the address.
Respondent number, what is the respondent number?
Respondent number 2.
We'll find out that. Let us see. We'll talk to my client.
Then it will come in the orders column. Learned counsel.
Fresh
Mr.
steps may be taken.
Mr. S.C. Biswas, yes, we'll give you a date. Learned counsel, Mr. S.C. Biswas is present for the appellant. Appellant, right, no? Appellant, and learned counsel, Miss R.D. Muzumdar is present for respondent number 2.
1.
Respondent number 1. The office note dated 24/11/2025 indicates that notices could not be served on respondent number 2, as no such person was found in the address. Full stop. Appellant may take fresh steps to issue notice to the respondent number 2 through the proper address, through his proper address. List this matter on date. 18 February. Should I send it to the mediation?
Lordship, that will be.
There's an element of settlement. She's saying there's no element of settlement.
Because owner has filed the case and liability is settled on them. We will be paying and recovering. How the mediator will decide? Is it a fit case for mediation? Lordship, there are categories of fit case and unfit cases. Registry is listing, fine. There is no dispute with that. But Lordship will look into whether it is fit case or unfit.
Let it go first, Lordship, thereafter, if nothing resolved, then.
No, but when they are not willing to settle, they are the main party who will pay and then recover from the owner. So what is the point? They are not willing.
Today is for consideration of that IA, which is for
No,
continuing.
no, not for consideration of IA.
Today is for
For
mediation.
For referral only.
I think
So then we will
it will be
bring it up on
documented.
orders column then, and then consider the IA.
Yes.
What is the difficulty if it plays before the mediation? Let us settle.
There is no element of
We are not
settlement.
going to, say that we are not liable, your liability is not there. Insurance company is not going to say that. Court has given a pay and recovery. Kobo neki insurance company, je amak nalage paisa to, no koi no. So let the court decide. It has to be decided by the court.
We'll bring it in the orders column and we'll dispose of your IA then.
Yes.
Learned counsel Ms. T. Som is present for the applicant stroke appellant, and learned counsel Ms. R.D. Muzumdar is present for the respondent number 3.
Appearing for respondent number 2 on behalf of Mr. M.U. Mandal.
Comma, and learned counsel
S.S. Ahmed on behalf of M.U. Mandal.
S.S. Ahmed is present on behalf of learned counsel Mr. M.U. Mondal, who is representing respondent number 2. Court court full stop lagay di diba thi, comma full stop lagay, full stop.
And one no claimant.
It appears that there is no element of settlement as the insurance company is insurance company has declined insurance company is not willing to settle the matter amicably, but to contest the proceedings, full stop. List this matter in the orders column on data reduction.
25th. Lordship, 25th would be a little difficult. Can it be March 2nd or 3rd? Anything? March 2nd? I'm obliged.
Much obliged.
May it please your lordship. My lord, the present appeal has been filed under section 23 of the RCT Act, my lord. My lord, at this stage, if a notice may be issued and the trial court record may be called for, my lord.
My lord. And only, my lord, regarding maintenance, lordship will consider non-exit.
Maintaining?
Because it is not against section, award pass under section 23, my lord. In execution proceedings.
Yes, my lord, I am challenging the executing proceeding. The learned tribunal has misinterpreted the judgment, the final judgment, and has.
We will decide it on the next day.
Yes, my lord. My lord, matter may be
because,
fixed for hearing. It is only in respect to question of.
The pleadings are not complete as it appears. Pleadings are complete.
No, today is the first day.
Today is the first day, my lord, for admission.
Let notice go, my lord. Then.
We'll call for a LCR.
Yes, my lord.
Item number কিমান হইলো?
14.
14.
Learned Counsel Mr. D. Rathi
Yes, my lord.
is present for the appellant and Learned Counsel Mr. Learned CGC.
My lord.
CGC or DYSDI?
CGC.
CGC and Learned CGC. Mr. G. Pegu is present for both respondent number 1 and 2.
My lord.
Okay. Respondent number 1 and 2 call for the records of the tribunal.
My lord.
Original records of the tribunal. List the matter after 4 weeks.
My lord, any date may be fixed in this matter.
List the matter 4 weeks of date of the auction. 26 February.
For hearing, my lord. Only question of law is there, my lord.
No, the records are not yet forwarded. We'll have to receive the records.
Yes, ma'am. On the next week, my lord, if it can.
Will it come?
What is that?
My lord, my lord. What
I am not sure if it will come.
May please the lordship. Notice may be go, lordship. Notice may be go, lordship.
Okay. Learned Counsel Mr. Aiko
Yes.
is present for the appellant. Post of appellant to take steps to issue notice to the respondents. One respondent? Respondent.
Yes, lordship, there is.
Make appeal respondents. Okay. List after 4 weeks.
4 weeks. Lordship, LCR, LCR.
Meanwhile, call for the original records from the tribunal.
Hello.
My lord, this is an appeal filed by the insurance company, lordship. It is on purely on quantum, lordship. Here, lordship, the deceased, the income of the deceased was not proved, lordship. No causal and relevant evidence is there. At this stage, lordship may admit the appeal and stay may be granted subject to deposit of 50%.
Learned Counsel Miss M. Chaudhary
Lordship.
is present for the appellant. From our insurance company.
Lordship.
Who is aggrieved by the judgment and order dated 28/11/2025 passed by the MACT.
Yes,
number 3, Kamrup Metro Guwahati. First of the appellant is aggrieved by the quantum of compensation awarded to the claimant.
The grounds I have stated, lordship. Paragraph 3, that is income, monthly income, interest, and COVID period interest rate given, lordship. These are the ground for on quantum. Ground number 3, 5, and 6. This is
As the monthly income of the deceased was taken at a higher
without any causal, no evidence is there.
Without at a higher rate, without any cogent
Cogent.
evidence.
Lordship.
Full stop. The rate of interest also is disputed by the appellant, full stop. It appears that further proceedings of the aforementioned MACT case number, what? MSC?
MST case number.
MAC case number.
MSC case 16554 of.
MSC case number 1654 of 2019 may be state, comma, till the next date of listing, full stop, thereby the operation of the order dated, operation of the order and the award dated 28/11/2025 is stayed until further orders, subject to the condition that the petitioner appellant deposits 50% of the awarded amount before the
Registry of
today,
dishonorable.
before the registry of this court within
6 weeks, sir.
6 weeks from today. Full stop. Meanwhile, issue admit लिखी दिया.
Lordship, this is in IA. I think this order is on IA.
We'll club it together.
Yes, Lordship.
And
That can be.
admit लिखी दिया.
Lordship.
Because I have mentioned that
Lordship.
appellant and all.
Yes, yes. Appellant is in appeal, Lordship, and IA is there 156 of.
ये तो आयत लिखी दिया.
Staying.
applicant বুলি লিখি দিলে,
Yes.
respondent লিখি দিবা. তেতিয়াহলে এইটো
IA
until further orders লিখি দিবা আৰু appeal টো লিখি দিবা. গোটেই ground খিনি একেলগে লিখি দিবা. তেনেকে লিখি পেলাই issue notice to respondents admit this appeal. ইয়াতে this also here we will dispose the IA.
Yes, yes, Lordship. I 156.
এইটো IA is disposed of লিখি দিবা. In terms of the above observation, I is just disposed of. All obliged, Lordship. Appeal to admit লিখি দিবা. কেইখিনি grounds লিখি দিলে admit লিখি দিবা.
First obliged.
This is an appeal for enhancement. For enhancement, Lordship, notice may go and TCR may call for.
Learned counsel Mr. M. Khan is present for the appellant. Issue notices to the respondent returnable within 4 weeks. Enhancement, no? Enhancement.
Enhancement.
Okay, list accordingly then.
And TCR may call for.
Call for the, meanwhile, call for the original records of the tribunal.
May I please, Lord? My lord, the in order, my lord, page 28, my lord. Here, my lord, the petitioners, my lord, they file a title suit, my lord, for confirmation of, for specific performance of agreement, my lord. And they took, my lord, fishery on lease, my lord, for 3 years. And it was extended, my lord, time to time. And last, my lord, lease was executed in 2023. And it terms was, my lord, up to 24.
Last lease was executed on
2023, my lord. For 1 year. Then it was, my lord, up to, my lord, 20 to 2024. Then, my lord, we, my lord, paid
to
28 to 2024.
20 to 2024.
28, my lord,
Oh.
28,
28 to 2024.
24.
Mm.
Then it is a fishery, my lord. We cultivated fish, my lord. Then, my lord, on oral verbal agreement, my lord, we paid, my lord, for ran for further 3 years. We have paid, my lord, 40 lakhs. There is a condition that it will be allowed for 8 years. Then
For how many years?
8 years, my lord.
You paid 40 lakhs for 8 years.
8 years. But they did not want to execute the agreement. Therefore, we filed the suit. And
Verbal agreement, how can they execute?
because, my lord, earlier also extended, subsequently they executed, my lord, agreement. This is a fishery, my lord. So on good faith, my lord, these are going on. Then they did not, my lord, execute the agreement, so we filed this suit, my lord, and along with the injunction petition.
Okay.
Then, my lord, Learned Trial Court on 3/12/2024, my lord, passed an interim order allowing us to continue in possession.
Okay.
The opposite party is a NGO, my lord, they filed objection.
Mm.
Then matter was heard on 25th of December 2025.
Mm.
And injunction has been rejected on the ground that the opposite party will not be compensated, my lord, in future if they will lose, my lord. The findings, my lord,
When
based
was the injunction order dismissed or injunction order rejected?
rejected, my lord, on 25/12/2025, page 28
It is 15/12.
or 15/12, my lord. I'm sorry, my lord. Here, my lord, the Learned Trial Court held that we are in the position, we are cultivating fish.
Mm.
And last observation, my lord, page 31. As the agreement has been expired, my lord,
Mm.
the opposite party will be suffer irreparable loss and injury. We are ready to pay the rent, my lord. We will pay the rent. So how they will, my lord, lose the revenue, my lord?
Who is the opposite party?
Opposite party is an NGO, my lord.
Mm.
So
The
in this
fishery
case,
belongs to
lord-
the NGO.
Yes, my lord. We are ready to pay the rent, my lord. So there is no question of loss for them. We have cultivated, we are not allowed to catch this fish. So notice
Is
me,
there any receipt of paying 140 lakhs?
no, a receipt of 5 lakhs was there, that was exhibited.
Bank statement?
No. Fish belong to us, my lord. At least we may be allowed to catch the all fish, my lord. So notice may go, my lord, and
This is. Okay. You want any interim order?
yes, my lord, earlier there's interim order. That was, my lord, vacated on 15 of December.
See, there's no ground to grant you interim relief. We'll issue notice.
My lord, the fish, my lord, we have cultivated in terms of the interim order granted by the
You
trial
don't
court,
have
my lord.
receipt.
So, my lord, if we are not allowed, my lord, then fish will be harvested by the opposite party. This is a
Where-
fishery, my lord.
Where is
So-
the petition? Where is the ground in the petition? Please read it.
My lord,
Petition. You do not have any receipt. Let us read the order. Oral order 40 lakhs. Oral agreement 40 lakhs. Let me read the order. You can
Lord.
sit down. I'll read the order.
Lord.
Sit down.
and in page 29, my lord, it is admitted that we are in possession. We have cultivated fish, my lord.
Can you wait for at least one date, returnable date?
My lord, in the meantime, my lord, the opposite party will catching the
You
fish,
see,
and
then I'll have to
otherwise,
pass-
my lord, if
then
the
I'll have
fish,
to see, I'll have to
Lord.
read this and I'll have to pass a reasoned order then. The reasoned order may be in your favor or may not be in
no,
your
my
favor.
lord, let the notice be go, my lord. They appear, my lord. In the meantime, status quo, my lord.
That's what I'm saying. To
Lordship.
grant it status quo, I'll have to pass a reasoned order.
Otherwise, my lord, if they, my lord,
No.
harvest the fish, my lord.
That I do not, that I will not go into your loss. I'll read this order and then I'll read your petition. Then if I
Lord.
find ground, then if you insist, then I will go like
Lord.
that. I'll proceed in that manner. And if you give me 1 or 2 weeks time, then I won't pass the reasoned order. Then I can issue notice and then I won't pass any order. of
Only, my
status
lord,
quo. Then I will, bring
harvesting
record
of fish
that-
may be stayed, my lord.
No,
because
that is what I'm saying.
Lordship.
If you give me 1 day,
Lordship,
I'll give you a short day.
Lordship.
If then I'll bring on a record that your interim order may be considered on returnable date. You do not want that. Okay, then
Lordship.
we'll go through the order then. We'll go through the order and the grounds of your petition then. then I'll pass a reasoned order.
Lordship. Because if they, my lord,
I understand. I
Lordship,
understand. You
because-
sit down, you sit down.
Lordship, Lordship.
But you see, this order may go against you or maybe in your favor also, I don't know. I'll have to read. Because you see, I'm inclined to reject because you do not have receipt.
Lordship.
That is the main, and you do not have the bank statement also
No, no.
paying 40 lakhs. So I'm more inclined to reject, but even then, let's see, sit down. I'll read the order and your ground. I'm not granting an interim injunction. I'll pass a reasoned order. Or you want me to issue notice?
Notice will go, my lord.
Okay, then. I'm not granting an interim, I'm not granting stays. Learned counsel, Mr.
R. Ali.
R. Ali, which item?
37 supplement.
Okay. Learned counsel, Mr. R. Ali is present for the petitioners. Full stop, issue notice to the respondent.
Only sole response.
Respondent returnable on after 4 weeks.
Well, some short date, my lord, because
Short date that it is on. 24th February, the prayer for interim stay may be considered on the returnable date. Very good one.
My lord, in this case, my lord,
Hmm.
in the present appeal, my lord,
Hmm.
the notice was earlier issued. But prior to that, my lord, in IA they appeared.
Hmm.
But here, my lord, notice was issued, but we could not take steps. But in IA they appeared, my lord. Connecting IA number 460.
They are caveators.
My lord.
Notices were issued to them, they are caveators.
No, my lord, no, IA was for condonation of delay, my lord.
Okay.
In IA they appeared.
Okay, that
Yes.
was for condemnation and delay and it was condoned.
Condone. Then they are, my lord, they are not appearing. The other party is not appearing. In IA, there is Bakalan number 4, respondent number 2, my lord. Respondent number 6. Others are statement.
What to do now?
If your lordship can, my lord, take the IA, the consul's name is there. If his name may be reflected, then probably he will appear, the respondent number 6. Otherwise, my lord, if notice is not served, it will be, we'll have to take steps again. But if your lordship can see, the IA, the person's advocate, name of the advocate is there, my lord. Record. IA 460/2020. If the name of the respondents is shown, my lord, and fix a date, we'll show it the name of my lord, respondent number 6, then probably the notice will be completed. No? Respondent 6.
6 to 9, but 3 and 5.
You have for respondent number 1 to 5.
3 5.
Huh?
3 to
3 to 5.
State welfare is under the standing council, my lord. So I am for 3 and 5.
3 government. Others, my lord, state we can serve copy, no issue, only with regard to respondent number 6, because the respondent number 6 is a private respondent, private party.
Otherwise, the respondents are not required to be heard. But as they were present in the IA,
Yes, my lord.
this is RSA, no?
Yes.
So their hearing is not as necessary, but as they were present in the IA,
Yes, my lord.
this is the reason why their presence is required.
Yes, my lord. That's why, my lord, if the respondents advocate for the respondent number 6 names can be shown in the cause list. Next, fixing a date, my lord.
We can feel so.
Yes. No, my lord, if your lordship may list the matter, showing the name of private respondent number
We can
6.
ask the registry to reflect.
Yes. But my lord, whether that is the technical issue, my lord. In IA, notice was served, but RSA, no notice is served.
It is not
Probably,
required only to be served.
probably not required because she appeared in the IA itself. So your lordship.
No, because this is a second appeal.
Yes,
Unless and until he is a caveator, he is not required to be heard.
that is also my lord, issue. Only thing is
A
that,
substantial question of law.
yes. Then your lordship may take up the matter for,
No, but there's an order, no?
yes.
To issue notice.
That is the problem, my lord.
How can I
That is.
revert
So-
my own order?
So you-
Earlier, there was an order to issue.
Yes, yes,
notice.
I have seen the order, my lord. That's why your lordship may kindly fix a date. In the meantime, I'll make an application before the registry
Okay.
to,
Learned Counsel Mr. J. Payang is present for the appellant,
yes.
and Learned Counsel Mr. S.C. Das
C and 5.
Huh?
C and 5. As
is
that.
present for respondent number 3 to
And
5. Full stop. The other respondents are not represented today. List this matter for hearing on substantial question of law, or list this matter. It will come in orders.
No, for substantial question of law, I will tell you.
List this matter after 1 week, 2 weeks.
2 weeks, my lord.
List this matter after 2 weeks. I'll not pass any order for notice or
Yes,
appeal,
yes,
so
yes.
that next
Yes.
day you can pursue.
Yes. Lovely.
Yes.
That one, yeah, 20. What happened to the appellant? IA?
No, lordship, it is RSA most probably.
RSA, yes.
RSA, we have appeared in the IA on receipt of notice of IA. Condonation of delay, we have appeared. But before submission of our acknowledgement, that order has been passed and RSA has been brought on record, lordship. So the appellant, if courtship allows, give them a right, maybe directed to give us a copy. Because we have not received the copy of RSA.
How many days delay?
I am for respondent 1. The delay has been condoned already, lordship.
Already condoned?
Already condoned.
Okay.
Delay condoned and
Oh, yes.
RSA has
They
been
have been
registered.
condoned.
But none.
RSA too? Oh, it to RSA. अच्छा, RSA too, yeah. They have not appeared today.
I'm for respondent 1.
Leonard, or the appellants are not represented today. Leonard Counsel, Mr. S.K. Poddar is present for respondent number 1. Full stop. It is submitted that they have not been furnished with copies of the appeal. Full stop. Extra copies to be furnished to the respondents. List this matter in after 1 week, 2 weeks. After 2 weeks.
2 weeks.
May it please your lordship. Lord, in the second appeal, I am the plaintiff. Suit was for illegal transfer of electricity connection in the name of respondent number 3. Both the courts below dismissed the suit. Initially, the electricity connection was in the name of the father of the plaintiff and the performer defendants. The connection has been transferred in the name of respondent number 3 on the death of the original consumer. That is my father. And the respondent number 3 alleged that earlier the connection was in the name of the father of the plaintiff as the head of the family. Now the property has been partitioned and the share has been in his favor. So the connection is transferred in his name. My lord, there was no such issue in the suit, my lord, regarding partition of the suit property. But both the courts will held that the suit property after partition, the shares fell in the in favor of respondent number 3. So there is no such illegality in transferring the connection in his name. My lord, I have formulated, there is no question of my interim order in the second appeal, my lord. And page 4-5 is the substantial question, or 3 substantial question of law I have formulated. So my prayer is that my lordship may admit this appeal and
Why you do not want the electricity connection to be given?
My lord.
Why you do not want the electricity connection to be given?
It was my lord, it was in my father's name, my lord. It has to be transferred to the legal heirs. He is not the legal heirs. We are the legal heirs.
Late Subal Chandra Das.
My father.
Then Saurabh Das and Jhuma Das.
My brother and sister. And
It is an appreciation of facts, my lord. That cannot be a regular secretary.
No, not the appreciation of facts. It has to be transferred to the legal heirs.
You're staying separately or in the same house?
Same house, but
Okay, how can you deprive somebody from electricity connection?
no, let him enjoy. But the name has been changed. It is in my name. It should be in my name. He is there, my lord. Let him enjoy the electricity. I don't have any grievance, my lord.
Well,
It is not my prayer also to disconnect the electricity from his house.
It is not your prayer.
Not my prayer.
Well, as per the precedent of Dilip death, my lord, the electricity can be granted to any person, my lord, who is in occupation of the premises, my lord, irrespective whether he is the owner or not. An occupier also can be can get an electricity connection in his name, my lord. My lord, these are the precedents, my lord. How?
What is the substantial question of law?
Substantial question number, my lord, page 5, my lord.
Page 5?
5 of memo of appeal.
Should this case go to the Consumers Court?
My lord.
Should this case go to the Consumers Court?
Consumers Court.
No. It will appropriate court is the civil court. I'm asking.
My lord, they took a in the statement they took a plea that the suit is barred under civil suit is barred, but the learned trial court has decided that no, it is not barred, and the appellate court has said that it is impliedly barred, not exclusive barred. It is impliedly barred. Your lordship will examine, my lord. I have no prayer for
Because
him.
we were also handling Consumers Court
My
as
lord.
district judges. All the electricity matters used to come to the Consumers Court. That is why I'm asking.
May my lord.
Except that under Electricity Act,
My lord.
all damages and any other relief is to come to the Consumers Court. That is why I'm asking.
Your lordship, if your lordship direct, my lord, I shall go to the consumer court.
Then there'll be no substantial question of law.
No substantial question of this. Or my lord, lordship may admit this and examine whether.
On one substantial question of law, and then we can pass a directive.
My lord, my lord,
to
my
go to
lord,
the
my
Consumer
lord,
Court.
my lord.
That main one substantial question of law. Huh?
One is a substantial question of law.
This, I think this has been correctly framed, so I'll admit it on this one.
My lord, my lord.
Whether the courts below committed illegality in not passing a
My
decree
lord, my
for
lord.
transferring, all right, on one substantial question of law. All right,
My lord.
we'll admit it on that.
Yes, my lord.
Transferring the name of the appellant as legal heirs of the original consumer in respect of, so I do not know about this regulation also. Electricity connection in the suit holding and thereby violating the provisions of clause 5.8.3.2 of the Assam Electricity Regulatory Commission Electricity Supply Code Regulation 2017. Okay,
My lord.
only one question of
My lord.
self-framed
Yes.
admitted.
Yes.
Okay. Page 5, what first substantial question of law 2? Page 5 what ase, huh? Okol number 1 2. Why you want to pay the bills?
My lord.
Why you want the connection in your name? You want to pay the bills.
My lord, I shall pay.
Okay. Learned Counsel Mr. KK Day is present for the appellant, and Learned Standing Counsel Mr.
B Das, my lord.
B Das is present for APTCL. First of this appeal is admitted on the following substantial question of law. Page 5, question number 1. Huh?
Notice to be issued.
Notice is already there.
There private
One
respondent. Private respondent.
that
For respondent number 1 only.
The others, yes,
Respondent,
yes, yes. Issue notice to the private respondents returnable within 4 weeks. Okay.
For respondent 1 and 2, my lord.
Oh, APDCL Learned Counsel is present for respondent number 1 and 2. All right.
My lord, obliged, my lord.
My lord, this is a very simple case, but it has been complicated by the government. Because Lordship would kindly say, this is a school named by B.R. Milan High School at village Hukuapeta, Post Office, Rauli.
This is for motion.
Lordship.
My lord, actually interim prayer was not considered. And my learned friend has filed a affidavit. Even in their affidavit, our case is substantially supported. That I will show you. So now question is this, my lord. The school is situated at village Hukuapeta.
What
But-
kind of interim order do you want?
We want that the original name of the school, where it is situated, that is B.R. Milan High School, Hukuapeta, Post Office, Rauli. But they want that Hukuapeta name should be omitted. Whereas there is the certificate
So
revenue.
what kind of interim order is required? We'll list it for admission. What kind of interim order is required? We'll list it for admission.
Done, of course, but a short date may kindly
Yes,
fixed.
yes, yes.
Lordship, if Lordship requires, Lordship will dispose of the matter. Lordship, we have filed an affidavit today, which is not on record, but I have an extra copy, Lordship, if required, Lordship. If the other side presses, Lordship, we are not trying to delay the process, Lordship. It's not a delaying tactics. It's alleged by the petitioner
No, I am
every
ready
date,
to
Lordship.
argue today.
Yes, Lordship. Lordship, we can.
I am ready. If your Lordship is ready, then I am ready to argue. I am not seeking dates. So no delaying tactics question
You
arises.
have gone through the objection?
I think objection may not be necessary.
Lordship, it is our objection, Lordship. We have filed it, Lordship.
They have filed an objection, but in one annexer, they have supported our case. In one,
All right, then we can dispose it of. If
Lordship.
you say so, we'll dispose it of today without taking it to admission column.
Lordship.
that up to your Lordship.
Lordship, an extra copy of the.
First, my lord, there was a state that a title suit was filed for changing the name. That was returned back by the learned civil court on the ground that 82 notice was not served. So that is one aspect of the case. And second
So
aspect
that,
of,
because it is a government, so that section 80 notice was not.
of course, necessary. But there
It
was
was
a
returned.
there was a petition for waiving that notice, but that was not properly and elaborately mentioned. Perhaps that is why the learned court below was not in a position to hear the matter on 82. That was not ready. So it is returned. Now we have filed the petition, the present date petition, the present CRPIO, for the purpose of taking back
the title suit as well as the name of the school should be remain as B.R. Milan High School, Fukuapeta, Post Office.
So as per section, steps were not taken, 2 months. 2 months time was not taken.
Not, that notice was not served.
You prayed for waiver of 2 months time.
No, we filed a petition that it should be waived due to urgency of the matter. But the learned court was of the view that this notice was not duly served.
So you want a
So
reversal of
that
that
was
order also?
written.
So they want a reversal of that order also?
Lordship.
But at present, we are mainly on one point, that is the name of the school.
But not the reversal of that order?
Because there is normally two matters may complicate the matter. And thereafter, if your lordship is considered view, then matter should be heard by the landed civil court. Because there is some disputes. Dispute is not for the sake of justice. It is for the sake of this dispute only. Because
Let me see
admitted-
your prayer there. Let us see the prayer. What is your prayer here?
Yes. Prayer may be seen page 12.
Okay.
Under the factions are stated above, it is most respectfully prayed that your lordship would be pleased enough to admit this petition, call for reference, issue notice to the respondent to show cause as to why the impugned order dated 14/11/25 passed by Inspector of Schools, Borpeta District Circle, Borpeta, changing the name as B.R. Milan High School, Post Office, Rauli, replacing the earlier name B.R. Milan High School, Fukuapeta, Post Office, Rauli, shall not be set aside and quashed. By Annexure 1, and or to show cause as to why the impugned orders dated 21/11/25 passed by the Learned Civil Judge Senior Division at Borpeta entitled suit number so and so, and in Ms. J case number, that was for injunction. That they should not change the name, shall not be set aside. So the interim prayer was that pending disposal of the rule, your lordship may be pleased to maintain its status quo ante as on 17/4/25.
Can you come against 2 orders in one petition?
Will
We have come against the injunction miscase also.
No, in miscase, that was for granting injunction that the name should not be changed. And actually earlier, school's name was as we have prayed for. Kindly see,
This order dated 14/11/2021 was passed in which case?
in 14/11.
14/11/2025 was passed.
14/11/21, that was passed by IS Borpeta. Now kindly see, have a look to page 17, my dear.
Okay, this is another order. This is this is an administrative order.
Administrative order.
Okay.
That was challenged by filing title suit. That was written on the ground of that not serving notice under section 80. So though petition was there under section 82 CPC, that was not considered. Now kindly see how the government authority are changing their minds every now and then, as they are the instrument of some people of the one rival group. They are
Is
not.
that administrative order, you must come through civil or
No.
not through a writ petition?
That was filed, rightly or wrongly, it was filed.
Administrative order.
Administrative order was challenged.
Challenge in the writ
Yes.
petition.
Yes, before that, municipal court, the civil court. But civil court returned. So as the order was passed by Landed Civil Judge Senior Division, so and that was an interim order, or say something not entertained. It was not entertained. No effective order was passed. So we have our prayer is that 115 we have filed this petition because the learned court having jurisdiction failed to exercise its jurisdiction or exercise the jurisdiction in a manner which has no sanction of law. The learned court may reject or allow, but he should not return the matter. Now kindly see page 17, ma'am.
Page 17.
17.
So you are asking to set aside D, that administrative order
That
as
is
well
page
as the
16.
order of the title suit.
And that is secondary matter. Our first thing is order of IS. Page 16 kindly see. First. Page 16, it is dated 14/11/25.
This, your objection is on record or not on record?
Lordship, it is not on record, Lordship, because we have filed it today, Lordship, because
Okay.
we received the signed copies today morning and we've served a copy to the petitioner and we've filed it, Lordship.
We'll have to consider this objection.
No, yes, I have received the copy of affidavit filed by them today.
Let us bring this on record.
Then short that maybe.
Yes.
On Tuesday, I think, my lord. On Tuesday next.
On Tuesday next.
Tuesday next, that is
Will it come on record? On
Lordship,
Tuesday next.
Lordship, it should come on record, Lordship.
Tuesday.
Learned Counsel Mr. M.U. Mahmood is present for
Petitioner.
the petitioner and Learned Standing Counsel.
Chandler R. Burwa for respondent numbers 1, 2, and 4, standing on the secondary.
Ms. Arbor is present for respondent number 1,
2, and 4.
2, and 4 and has submitted that an objection has been filed by the respondents number 1, 2, and 4, which is not on record. Post of registry to place the objection on record. Place this matter on Tuesday then.
3-2.
Lordship.
3-2.
Hmm.
Obliged.
Then we'll hear finally on Tuesday.
Then an attempt may be made to dispose of the matter on that day. That may be observed kindly.
I'll be there. I'm sure I'll be there.
Yes.
Or they won't keep me here in this bench only for 1 week. I'm sure I'll be there. I'll dispose it.
Obliged.
May it please your lordship. Your lordship, on the earlier occasion, there was a direction for taking steps to dusty service upon respondent number 1, 2, and 6, your lordship. Accordingly, your lordship, we have taken steps to dusty service. An affidavit to that regard has also been filed, your lordship, and that is on record.
All right.
Services completed, your lordship.
I'm appearing for respondent number 1, 2, and 3.
Oh, you're already, she's already here.
Applicant, after receiving the dusty notice.
Okay.
And
Then
respondent number
anybody else
4.
left out?
Yes, respondent number 4 has also already entered appearance. And as with the respondent number 5 has already been struck off, your lordship. So services come.
So we'll.
Yes, NCR has been received, your lordship. It may be fixed for hearing.
Learned Counsel Ms. P. Bothaguna
Lordship.
is present for the insurance company. Full stop. Learned Counsel Ms.
B. Datta.
B. Datta is present for respondent number
1, 2, and 3.
1, 2, and 3. Full stop. Respondent number 4 has already entered appearance, although the respondent number 4 is not represented today. As the records are before us, list this matter for admission, for
Hearing.
Already admitted, no?
Yes, your lordship, it is admitted.
Hearing.
Obliged.
For hearing after data the didn't Corona matter, sir. After 2 weeks, hearing after 2 weeks.
19 April. Obliged.
On last occasion, your lordship is allowed to take paper publication. We had submitted to the registry, we have not received it today, lordship, so may require some time to take paper publication.
Okay.
I am for respondent 6. Other respondent that we record to.
Okay. Learned Counsel Mr.
K. Jain, lordship.
A. Jain, no?
K.
K. Jain is present on behalf of Learned Standing Counsel?
No,
Or
lordship, it's
private?
private.
Learned Counsel Mr. S.C. KL, representing the appellants. Full stop. The Learned Counsel has prayed for time to issue notice through paper publication. which is allowed. Learned Counsel Mr.
S Nath for 6.
S. Nath
For 6.
is present for respondent number 6. List this matter after 4 weeks.
Lordship. Much obliged.
Lordship, hearing this case, service is complete. LCR also received lordship. Let the matter be listed for hearing in the second week of February.
Okay. Parties are represented as a trial court records are before us. List this matter for hearing on second week of February.
11 weeks.
After 2 weeks.
Second
This
week
is-
of February.
Okay, on date of the reduction, second week of February, লিখাত কে। Time আছে না second? না, নালাগে, on third week. 17 February.
Nice.
Maybe Lordship. Lordship, I'm for respondent number 1, and respondent number 1 has filed an application for early hearing, which was allowed by the Lordship. So matter may be fixed for hearing of the matter. LCR already been received.
So didn't.
Oh.
This IA was allowed,
I saw the allowed, Lordship.
already allowed.
Already allowed.
Learned Counsel Mr.
R.A. Chaudhary.
R.A. Chaudhary is present for the appellant and Learned Counsel Mr. G.
G. Kakoti for respondent number 1.
Is present for respondent number 1. So as the application for early hearing was already allowed, list this matter for early hearing on date of the video. 19 February.
19 February. That's it.
You have any interim order in your favor?
Yes, till the disposal of.
That is why he has asked for early hearing. Interim order shall continue or till the disposal.
Yes.
Okay, নালাগে interim order কথা লিখিব নালাগে। নাই আহা ন?
26.
Parties are not represented to release this matter after 1 week. On failure of appearance of any of the parties on the next date fixed, after 2 weeks, লিখিলে। List this matter after 2 weeks. On failure of appearance of any of the parties on the next date fixed, necessary order may be passed.
27.
May it please your lordship. Your lordship may peruse office note dated 27/1/2026, your lordship. Neither ID card nor unserved notice has been received in respect of respondent number 1 and 2, your lordship. Your lordship, notices were issued on 19/1/2026.
We'll await it.
Yes, your lordship.
Service report on the respondents, how many
1 and 2 only.
respondents is awaited? List this matter after
3 weeks.
3 weeks.
Obliged.
Here, LCR has been received, Lordship.
Parties are also present, I think.
No,
Also
Lordship.
parties?
No, 2 and 3 service not complete. They are necessary parties because.
Learned Counsel Mr. S.P. Sharma
Yes, Lordship.
who is present for the appellant. Learned Counsel Mr.
AB Day,
A.B. Day
my lord.
is present for respondent number
1.
1. Service report on respondent number 2 and 3 is awaited. List this matter after 2 weeks. 3 weeks, 2 weeks?
2 weeks, Lordship.
2 weeks.
Because already.
My lord, there is an IA is there, my lord.
Yeah,
There
madam.
that
I.
I had to go through.
for the stay which they have filed,
Hmm.
the IA is also listed, my lord. That IA may be taken up.
You want to?
No, no,
press-
I'm just requesting that.
You're
your
for the
IA
claimants.
Lordship, first of
For
all,
claimant.
the appeal. No, hey, 2, 3, Lordship. No, wait, hold on. Lordship, thing is, we had taken steps by speed post because the new rule is
Yes,
that.
yes.
So Lordship may direct the registry to verify the postal receipt return.
Okay.
That order may be given in the appeal, Lordship. Because otherwise, if time elapses, then they
It is
cannot do.
submitted, the steps have been taken. Steps have already been taken. Therefore, registry to verify the
Tracking report.
postal, what?
Postal
Consignment
tracking
track,
report.
huh?
Postal tracking report.
Postal tracking report.
Yes, sir.
If notices have already been served on respondent number 1 and
No, two
two
and
and
three.
three.
One is him.
Okay. You are the claimant?
Yes, my lord, I'm for the claimant, my lord, in this case. Otherwise, I'm, my lord, if the stay order, my lord, wishes to grant to them, then 50% let them deposit. That is my only, because my lord,
So
here,
press the stay petition.
Right now, we are not pressing, Lordship, because we need the owner and driver to be present, 2 and 3. That's why I spoke about the.
All right.
my lord, on that case, my lord, a date may be fixed because
No issue.
what I'm
Date
submitting,
also do
my lord, the here issue is this, my lord, I'm already 79 years old, my lord.
I understand.
And this, the delay,
But I think this is, they are disputing and.
no problem, my lord. If little early dates can be given, my lord, then I can be accommodated, my
I'll
lord.
give you a short date.
My lord, please.
Highly obliged.
May I please, your lordship? In this case, I am appearing without receiving the notice because in the trial court, the order of this honorable court granting a stay was filed. So on the basis of that, I have filed the wakalatnama on behalf of all the respondents, your lordship. So my,
Admission column next. As in when.
and after 2 weeks, I need some time to go through it and a copy, my learned colleague will be providing it to me. Your lordship.
I'll find a copy. Better may come up in admission column.
Learned counsel, Mr. S.K. Poddar is present for the petition and learned counsel, Mr.
A. Biswas, your
A.
lordship.
Biswas is present for respondent number 1, 2 and 3.
1, 2, 3, 4.
1, 2,
Four.
3 and 4. Full stop. Extra copies to be furnished to the respondents by the petitioner. Please this matter in the admission column.
Yes, your lordship. After
Do
2
you
weeks.
want records? Do you
No,
want
LCR
records?
Let's say, I don't think it would be
I don't-
necessary.
yeah, most of the.
Okay. In the admission.
A simple order is challenged here. Lordship.
So a date may be fixed, your lordship.
Oh, date of the Dixon. When do you want?
10 February.
Huh?
10 February.
10
18th
February.
or 19th, Lordship. If
18th
not-
or 19th.
If not inconvenient.
And,
19th.
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 Obliged.
Highly obliged.
Copy to you.
Lordship, the IA is for condoning delay of 101 days, Lordship. Lordship, what happened before we filed an regular second appeal? And on 25/6/2025, that was withdrawal with a liberty to file a CRP because we filed it in a wrong forum, Lordship. And in that procedure, there has been a delay of 101 days. So my learned
have any
friend is
objection?
appearing.
I am appearing from the respondent number 1, opposite party. There are other opposite parties, but as per the last Lavazima court's order, their service has been completed.
Yes, complete.
I do not have any objection on the IA.
Yes, Lordship.
Learned counsel, Miss
F. Ahmed.
F. Ahmed is present on behalf of the petitioner, no?
Yes, Lordship.
Petitioner.
Applicant.
On behalf of the applicant who has filed this application of delay of
101 days.
101 days in filing the connected revision petition.
Revision petition.
Connected revision petition, full stop. Learned counsel, Mr.
P. Sengupta.
P. Sengupta is present for respondent number
1.
1 and has no objection if delay is condoned.
1 and 2. Lord.
Respondent number 1 and 2 and has submitted that he has no objection if delay is condoned. Where is the Lavazima court's order dated?
That is, Lordship, 20/01/2026. 19/1/2026. The second slide.
The Lavazima court's order dated 19/1/2026 reflects that notices have been served to respondent number 2 to 6.
2 to 6.
So we have 6 respondents.
6 respondents.
Actually, I will be appearing for two also, the branch manager of the
Yes,
bank.
yes. Respondent number 3 to 6 here. 3 to 6. Where is your ground? In which paragraph? It is
Lordship will
submitted-
find at ground number 5, that is page number 5.
It is submitted there by the applicants that the delay was not intentional. Full stop. The applicants on bona fide belief. The applicants, no applicants, the applicants on bona fide belief. Filed RSA 41/2025 within the period of limitation. Full stop. But at the time of admission hearing, comma, a issue regarding to maintainability of the RSA was raised. And thereafter, the order dated 25/6/2025 was passed for withdrawal of the appeal. Full stop. There was consequentially owing to the summer vacation. Or vacation. What vacation? It will be summer vacation only.
Summer vacation.
Owing
spelling
to the
mistake.
summer vacation. There was a delay in filing this, in filing the connected revision petition. Full stop. I have considered the submissions at the bar with circumspection. Full stop. I have also taken into consideration the fact that notices have been delivered to the other respondents as well. Full stop. The respondents, the other respondents are not present today, not represented today. Full stop. Their sufficient grounds have been assigned by the applicant. Full stop. No mala fide can be attributed to the applicant. Considering all aspects, the delay is condoned. Full stop. Registry to register the connected revision petition.
Deeply obliged.
In terms of the above observation, this application stands disposed of.
Deeply obliged. Apa number tu ni kita
That, my lord, as per office note dated 28/1/26. As per office note dated 28/1/26. Service report in respect of 1A, 1D and 1E is complete, my lord. In respect of 1C, my lord, insufficient address has been endorsed by the report, my lord. And 2 is possibly expired, my lord. As per report, my lord. And in respect of respondent number 1B, my lord, neither ID card nor answer notice has been received by the section 3D.
These are the newly implemented legal errors.
Yes, ma'am.
And you are present for?
Well, I am appearing on behalf of 1A, 1D, 1E. 3 respondents. 1C, my lord, insufficient address, 2 is deceased. And regarding 1B, my lord, no ID card received, my lord. So they probably will have to take fresh steps.
Maybe, but in respect of respondent number 2, so particulars may be furnished. So
You
that we
find
can-
particulars of respondent number
Respondent number 2.
My lord.
Okay. Because respondent number 2.
Expired one.
Okay. Learned Counsel, Mr.
SR Borguya.
SR Borguya is present for the applicant. Stroke appellant. Post of Learned Counsel, Mr. S. Das is present for respondent number
1A, 1D,
1D
and 1E.
1E. Full stop. No answer notices have been received back as respondent number 2 has passed away and the address of respondent number 1C is not sufficient, full stop. No service report on respondent number 1B is awaited, full stop. Applicant may take fresh steps to issue notice to respondent
1B.
number 1C, I think.
1C,
1B and 1C, 1D, no AD received.
B is not required.
Yeah,
We'll await.
B is
Await.
awaited.
Respondent number 1C through proper address, full stop. The respondent may furnish, the appearing respondents may furnish
The details of the legal
details of
heirs of
the deceased respondent number 2.
full gender.
Okay. List this matter after 4 weeks. 4 weeks.
Highly obliged.
My lord, even possibly 2 weeks, my lord, because the execution will
Okay,
make start.
2 weeks. Okay. List this matter after 2 weeks.
Obliged.
May I please, Your Lordship?
Mm.
Lordship, I have filed this IA for withdrawal of the amount, Lordship, which has to be deposited, Lordship. Judgment has already been passed, Lordship. Only
The
respondent
case
number
has
one-
been disposed of, Your Lordship.
Disposed of.
Okay.
So, Lordship, I may be allowed to. Respondent number 1 expired, Lordship.
Judgment has been passed in this case.
Yes, Lordship. Respondent number 1 expired during the pendency of the appeal, Lordship. I was not aware.
Ah.
So it's a death case, Lordship. I'm the mother, Lordship.
Okay.
The father expired, Lordship. I may be allowed to withdraw, Lordship.
Learned counsel Miss
P. Borba, Lordship.
P. Borba is present for the applicant. And learned counsel P. Bothakur. Miss P.
Bothakur.
Bothakur is present for the insurance company.
Respondent number 1.
Comma, respondent number 1. Whose of this application is filed for withdrawal of the award,
Awarded amount.
awarded amount. By
Yes.
judgment and order dated MSC appeal.
176/12.
Judgment and order dated 16/5/2025 in
Yes.
MSC in connection with MSC appeal number 176, 2012. Comma, awarding an amount of rupees 6,20,625, 620,625 to the claimants, full stop. It is submitted that
Along with 9% interest.
one of the claimants, Subodh Kanti Mozumdar, has already passed away.
Lordship.
Full stop. We have considered the submissions at the bar. The applicant stroke appellant is hereby allowed to, you were the appellant?
Yes, Lordship. No, no.
We are the appellant in the main appeal, they are the
The
applicant
applicant is
here.
hereby allowed to withdraw the compensation deposited before the,
Yes, yes.
here you have deposited.
Lordship, whether the amount has been deposited or not, that I will have to take instruction, Your Lordship.
They will deposit, Lordship.
In the meantime, if not deposited, we will
Withdraw
deposit.
the amount of compensation awarded in favor of, awarded in a favor.
Lordship.
Obliged.
In terms of the above observation, this IA stands disposed of. This application stands disposed of.
Awarded amount, Lordship, 6,20,000
I have
along
mentioned.
with 9% interest.
Along with 9% interest
From the
from
date
the
of
date of filing of the petition.
Yes, Lordship.
Obliged.
Lordship, item number 34. Your Lordship, under emergent circumstances, I filed 2 applications in the case. Lordship, the condonation on if application.
You have to issue notice and condonation.
In condonation, it is already issued, Lordship, but I have mentioned for listing of IA number 114 before this honorable court. On a certain ground, I would like to this. Lordship, what happened is in this case, second appeal, Lordship, was dismissed for default way back in the year of 2019. While it was dismissed for default, Lordship, within the prescribed period of limitation, we filed an application for restoration of the appeal, second appeal. And that is numbered as IA P417 of 2019, and it is before your Lordship. Thereafter, Lordship, during the pendency of the restoration application, notice was being issued to the decree holders. I was the judgment debtor. Now, during the pendency of the restoration proceeding, Lordship, both the decree holders, they expired. Both happens to be husband and wife, respondent number 2 He expired in the year of 2019, and 23, the wife, the respondent number 1 decree holder, she also expired. Now subsequently, Lordship, thereafter in 2025, we received a notice from the executing court that the legal heirs of the decree holders, they had substituted themselves in the execution proceedings, and aggressively they have been pursuing with the execution proceedings since we received the notice.
You are the judgment debtor?
Yes, I was the judgment debtor. I preferred the appeal, and my brother also. But my brother, he didn't prefer any appeal. I came before this honorable court. Then the substantial question was also admitted, and it was fixed for hearing, but it was dismissed for default. In such situation, Lordship, I have pressed one application under section 151 regarding the stay of the proceedings till decision of the restoration proceeding. Because, Lordship, now the surviving list before this honorable court is the restoration proceeding, Lordship, and they were fully aware that the restoration proceeding was pending before the honorable High Court. Only thing is that, Lordship, I was not present here from 13 onwards. I was residing outside Assam. While I received the notice, Lordship, I immediately filed for substituting the names of the legal heirs of the deceased respondents. So till then, since they are already there in the executing court, before the executing court, Lordship, if in case, Lordship, since my restoration application was filed within limitation, if I succeed in
How
restoring,
can you jump over in this manner? One case is pending for condonation of delay.
because
Then
there
you
is,
are taking the case from underneath and jumping over.
no,
How
no,
can you
Lordship,
jump over
because
in this
it was filed along with the condonation only. Because I have made out
manner?
the case.
Delay has to be condoned.
But Lordship, there are judgment in that respect, because when any emergent situation, if justice demands, Lordship, under 151, it can be invoked to grant stay. I have a judgment of this honorable court, but the subject matter is quite different. But if Lordship
No.
will use in that such situation,
No.
Lordship.
You cannot jump over in this manner.
Because Lordship,
If you are bringing subject matter not similar to this, how can I help you?
I have,
You are relying on some authority, the subject matter has to be similar.
Lordship, if for a moment, Lordship, if peruses the judgment,
No,
rest is
the
on-
subject matter has to be similar.
it is on the point of limitation only. Since once a second appeal was there, Lordship, and it was
Let's see.
filed, it's one judgment is there, Lordship. I would like to place my case. Rest is on your, for this honorable. Is reported in 1997 1 JLR 287, Lordship, and para number 2, Lordship.
It was long before 2002.
Lordship, yes, but in such situation, Lordship, if the execution
Order
proceeding is being satisfied, if orders are, like if the execution proceeding is completed, Lordship, this all accompanying application will be infructuous, and they will very well, Lordship, that the proceedings are pending till then only, till the returnable date. If Lordship stays
No,
the
no, I cannot
proceeding
pass any illegal order. Please read the judgment.
in para number 2, FRA
CPC gone, yes, sir. Now we are going by the new CPC.
Yes, yes.
And this is that old CPC before 2002.
Two, Lordship. I'm sorry, Lordship, in that situation, but since 151, I'm pressing.
Even then, I'll have to check if this type of orders have been overruled or not.
Yes, that is one aspect,
Mm.
Lordship.
You're
So-
bringing an order of this
Yes, yes.
court, that to single bench.
Yes, yes.
How can I rely on in this manner? I may differ.
Lordship, I have made out the case. Rest is on this before this honorable court.
না CPC হয় এখানে হয় না 2002 ঠিক আছে Please read the judgment.
Lordship, in para number 2, a fair interpretation of Order 41 Rule 3 of the CPC would be that it requires the appellant presence and appeal after expiry of period of limitation. It shall be accompanied by an application supported by affidavit stating that the reasons for delay in preferring the appeal along with the memorandum of appeal. After all, Order 41 Rule 3 is a procedural law, and this procedural law must be interpreted in such a manner that to advance the cause of justice. If the power to grant the stay is not given in exceptional cases, this will cause sheer injustice to the appellant who may be prevented from filing an appeal in time because of the compelling circumstances. After all, law cannot be allowed or utilized to cause injustice. In such a situation, court can exercise power under section 151 of the Code of Civil Procedure to grant relief in such a case if the justice demands. That is the mandate of
Give
law.
me some more reliable judgment. We'll give you one more day. When is the execution order? When is the next day?
Next
fixed for
date,
execution
next
order?
date is on 27th of February, Lordship.
So to next week you bring some more reliable
Yes, yes, yes.
decision.
Yes, yes, Lordship.
Not a decision of a single bench of this.
Yes,
court.
Lordship. I am sorry, Lordship. I didn't go through, but I will bring some more judgment and I would like to make out a case because if Lordship
Next week itself.
next week, yes, by next week, if possible, Lordship maybe feels to fix it on Monday. I will because
Not
if execution
Monday.
is proceeded
Monday
in
we have too
satisfied,
many
Lordship.
cases. No, it's okay. Monday we have too many cases. If you can find any reliable judgments,
Yes, yes.
then I can if I can pass an order, jumping over. This
Because
is what
Lordship-
you are
Lord-
asking
Lordship,
me to
yes,
do.
yes, because I understand, Lordship, because
Okay,
Lordship.
if I can pass an order, then I'll pass immediately and upload it on the same day. You don't worry.
Yes, yes.
But not on Monday,
Tuesday, Wednesday,
Wednesday.
Wednesday.
List this matter on
Because
Wednesday.
Lordship here said aspect of 151 I have relied.
understand. Yes.
151 I
On that
have
front, you
relied.
bring
Yes.
any judgment
Yes.
more stronger
More
judgment.
stronger judgment. I have to search
Yes, you
journals
do your
because
research.
because if
If you want an order, then you
because-
must do your research.
because my case is that Lordship, I have all right to pursue the restoration
That is why
proceeding.
allowing you
Yes.
time without dismissing it instantly.
Yes, because if it gets restored, Lordship, everything will be
That's why
impacted.
I'm allowing you time.
And they have jumped before the executing court.
Yes, yes, let's
That's
see.
that's the aspect I'm placing.
Let's see.
Yes, yes, Lordship. On Wednesday, Lordship.
Yes.
Court. Yes, yes, yes. Much obliged.
May I please allow me? Lordship, the IA is for delay condonation, my lord. Delay condonation of 53 days in filing the appeal, connected appeal.
We'll have
Lordship.
to issue notice.
Yes, Lordship. Lordship, I have a humble prayer, my lord. Respondent number 2 and 3 may be stuck of being the owner and driver only. And the appeal is to the extent of enhancement.
Now later you think about the stacking of. Now you issue notice to the claimants, it's sufficient. Issue notice to the respondents, returnable within 2, 3, how many weeks?
4 weeks.
4 weeks. This stack of will not hear them.
Lordship.
Owner and driver, they do not participate only in any case.
Lordship. Obliged, Lordship.
May it please your lordship. My lord, the instant petition, my lord, application, my lord. The second appeal, it was admitted on 31st, 23rd July 2025 on 3 substantial questions. Kindly have a look. No, I'll come. I am not before that, my lord. The admission order, my lord. 23/7/25.
23/7/25.
Yes, my lord.
Okay, 23/7/25.
Yes, my lord.
Yes.
That order lordship will find, my lord.
Mm.
And this honorable court is admitted, my lord, very next, my lord. The 3 substantial question of law has been found. Yes, lordship is found in
Yes,
paragraph
yes,
6, my
yes.
lord. And then, my lord, lordship in paragraph 7, my lord, 8, issued notice and admitted and called for the records, my lord, in the second appeal, my lord. Lordship has got it, my lord?
Mm.
Yes. Now, lordship, can you have a look? The order
Paragraph 7.
6. Then, my
Six
lord.
was under subject
Yes,
of
yes,
question
yes,
of
yes. And lordship, paragraph 9. Registry shall call the records and it's already admitted on this 3 substantial question of law and records call, my lord. Then, my lord, here we have filed one IF or stay of the proceeding that is 2235 of 2025. In this IM, my lord, one order passed. Kindly that order is important. But on very same day, that is on 23rd July 2025.
This is in the IA, no?
In the IM, in the stay application.
Same day.
Yes, my lord. On lordship, paragraph 2, my lord.
IA number 2235.
Yes, my lord, of 25.
Mm.
Para 2, my lord, in this application under Order 41, Rule 5 of the CPC, is preferred by the applicants for staying the operation of the judgment dated 28/6/24 and decree dated 5/7/24 passed by Learned Civil Judge Senior Division Hailakandi, the title appeal number 2022. It is to be noted here that by judgment dated so the decree dated so Learned First Appellate Court has allowed the appeal and modified the judgment and dated so and decree dated so passed by the Learned Munsif to Hailakandi trial court title suit number so. It is also to be noted here that The white judgment dated 6/7/23 and decree dated censure passed by the learned trial court had partly decreed the suit on contest. Let notice be issued to the opposite parties within a week from today by registered post on edition process. My lord, accordingly, in the light of this stay application, direction, my lord, we have taken to all the respondents, my lord, and my learned friend is appearing for the respondent, principal respondents number 1, rest respondent 2 to 10, the service is not complete. My lord, my humble subject, I would not have praised this application at least until completion of all respondents, my lord. Here the situation is different, my lord. My lord, during pendency of the matter, my lord, appearance, my lord, normally what happened, my lord, in second appeal, well admitted this call, some substantial question law, records call, and I also state, but here in my case, though admitted, records call, but on stay application, issued notice. Subsequently, my lord, unsurprisingly, my lord, present respondent, they have execution case, issued notice to us, appearance on 21st June to January 2016, that it is fixed on next 13th of February, my lord, for our appearance. Since, my lord, our stay application and during pendency of the stay application, my lord, this honorable court issued notice how they can proceed for execution procedure. This situation demands me to frame of my application. Kindly, my lord, have a look. My lord.
Because there is no stay, that is why they have filed the execution process.
Therefore, my lord, how they can, if they file execution process, then what is the meaning of this filing of a second appeal here before this?
No, there may be
Yes,
another
and
meaning,
this,
but
this
there is no stay.
honorable court is stay, my lord, issued notice to all the respondents on stay application. During pendency of the stay application, they
You come
initiate.
against the order on the execution proceeding.
My lord,
You come against the order. in
no,
the
that is different issue, my lord. Against execution process, different issue. In second
No,
appeal,
no, here you get any benefit.
this is
No,
my
it-
stay
there is
application.
no
This is my
stay.
stay application, my lord. This is I for stay application, my lord. And this honorable court notice to all the respondents regarding so far as my stay is concerned, my lord. During the initiated
No,
one
but not by verbal submission. You bring some.
this is my execution application. Lordship pardon, I can file additional affidavit.
No, file an affidavit.
Okay, then my lord, then I will, my lord, the next date fixed on 30th of
No,
February,
tomorrow you
then
file.
before that,
Yeah.
my lord, that means I will file, by Tuesday I will file, my lord. So lordship kindly fixed in on,
Tuesday.
lordship, I am praying, my lord, estimated. Then next date fixed on 13th, can it be on 11th?
Yes.
11th of, sorry, no, my lord, on 6th of February.
Yes.
Yes, my lord.
Learned Counsel, Mr. P.K. Deka. P.K. Deka, no?
Yes, my lord.
Is present for the petitioner, for the appellant, stroke applicant, and Learned Counsel, Mr. M.J. Kadri is present for respondent number 1.
One, my lord.
Please this matter on.
My lord, can it be on-
Sixth.
on 9th, my lord? I will not be available on 6th, on 9th.
9th, my lord.
Okay,
9th,
on
my lord.
9th.
9th. No issue.
9th.
No issue. And my lord, some observation so far as,
I will stay. You filed that, not in verbal
yes, some
submission.
observations, lordship allowing me to file application, that means observation, my lord.
The learned counsel for the applicant may submit and may
That-
submit.
That
any
execution notice,
Appropriate application.
appropriate application,
Submit appropriate execution.
deeply obliged. 9th.
For solicitor Lulu Paino.
Lordship, in this case, there is no possibility of settlement, amicable settlement. So date may be fixed for hearing, your lordship, in the month of February.
This was sent for settlement, no?
Yeah, not for settlement, but then whether it can be sent to mediation or not.
Oh,
On last occasion it was.
okay, okay. All right. We'll fix a date for hearing.
Lordship.
Same interim order passed already at it may be continued.
All right.
In the month of February, you will see.
February, when?
Any day-
February
Tuesday
2nd?
first, Lordship.
Huh?
Not only, no, there is urgency, your lordship.
Okay.
Please see.
Parties are represented. Learned Counsel Dr. R. Sharma has submitted that this matter is of urgent nature. List this matter for hearing on 26 February.
Interim may be continued.
Interim order shall remain in force till the next date.
Well, may pray for to continue until disposal of the appeal. Otherwise, I have to pray every date, my lord.
Doesn't matter, you pray.
Just fix for
Every
hearing, final hearing.
little effort gives you good results.
My lord.
Obliged.
Are you asking?
Oh, that's-
Okay,
Yes.
Senior is not there. He is having some health issues today.
No, yesterday what I had asked, no, it's okay. It was there. I thought it was not there. It was issue number 5 I didn't see.
It is there, my lord. I see, I have
Then
taken.
the decree was also not prepared correctly, not properly.
My
The
lord,
decree
prayer was made, my lord, in the sense, my
No,
lord,
that prayer decree has been allowed as prayed for.
as prayed for.
So
In my
see,
prayer, it is there,
dismissing this appeal and that decree will be prepared accordingly.
my lord.
Huh?
My
That
lord.
decree will be
And my
prepared.
judgment, whatever I have relied, my lord, I think my junior has,
Yes, yes.
that may be
Only
reflected.
one judgment, that Suraj Lems,
Yes,
that
my
has
lord.
been repeated again.
Yes, yes, my lord.
It's okay.
Fair and this.
I'm dismissing it. There's no case actually.
Lordship.
And then that what I was asking for, there's no order, there's no, it was passed in one line, so.
Yes, very small, my lord.
Small.
Yes.
See, and as I was talking and asking, so I couldn't notice it.
Actually, my
After-
lord, I prepared last 4-5 days, my lord. Either this said they have taken time, my lord, adjournment. My brother in the meantime expired.
Okay.
Just 2 years elder to me. Suddenly he got stroke in Shillong. Then we brought here, we did operation also, but
Oh.
unfortunately he lost it. So I had to go to Silchar.
Nowadays the stroke is also.
Very, my lord, in 4 regions there.
Occurring suddenly, young boys are also dying.
27 years of old girl, my lord, very young and lean and thin, my lord. Suddenly she got fever and she got stroke in same hospital.
One advocate also passed away at the age of 55 or 50.
Yes, that Rabba.
Very sad.